Hello, fellow teachers and peers. My name is Robert Godwin, and today I will be covering my Landmark Cases project of the United States of America and how they hold importance to it. Here's a quick overview. In this following assignment, I plan to research 19 different landmark court cases in six different areas of U.S. history. I will then run down each court case, discuss the problem, how the problem was solved, and why it is important to U.S. history. I plan to gather each court case from oyez.org. Here we start off with the Era 1 in the early Republic. The first court case will be Ware versus Hilton. This court case would be decided in 1796. In Ware v. Hilton, the Treaty of Paris led creditors to both of the United Kingdom and the United States to pay off and receive debt money. But Virginia made their own laws, declaring that they did not have to give up their debt to an alien enemy. In this case, the big question asked if the Treaty of Paris had precedence over the state legislation, in which it was declared that these treaties hold as much precedence in the states as it did across the pond, which called the Virginia legislation unconstitutional and established the Supremacy Clause, that the federal government was supreme in lawmaking. This case holds importance today as many federal laws are created, while many states try to circumnavigate these laws through their own legislation. Court case number 2 is Hilton versus United States, which was decided in 1796. Hilton was a carriage owner, and when Congress passed a $16 tax on all carriages owned by businesses or people, he argued that it violated the act that Congress that should be proportionate to the population of the country. The main question was if the carriage tax should be apportioned across the states, as it was not a direct tax on any consumer goods. This case is ruling that the carriage tax was not a direct tax, and therefore was not subject to the same allocations as a direct tax. This would set a precedent for the Supreme Court's ability to check and balance the acts of Congress. It is equally important today as there will always be a suggested act from Congress that will seem unconstitutional and will be checked and balanced by the courts. Court case number 3 is Chisholm versus Georgia, and it was decided in 1793. Alexander Chisholm wanted to sue his home of Georgia because he gave them provisions for the Revolutionary War, but never got paid for them. The problem of this case was it wasn't known if a citizen could sue for their home state. This problem would be solved when it was found that the Constitution superseded the state's sovereign immunity, being added later in the 11th Amendment. This case is important as it protects the civilians from not obtaining reparations from the states if they are wronged. Era 2 is the Martial Courts. Number 4 is Marbury versus Madison, and this case would be decided in 1803. Jefferson defeated Adams in 1800. Adams passed a new Judiciary Act before his inauguration that created a new court system. Marbury would be chosen as a justice, but would not become a justice under Jefferson, which caused Marbury to sue. He argues that he has a right to earn his commissions from his role, can sue for his commissions, and that the Supreme Court does not give authority to order the delivery of commissions. The court could not grant these terms for Marbury because the Judiciary Act and the Constitution conflicted with each other. This is monumental in establishing judicial review, or the court's ability to review an object's constitutionality. Court case number 5 is Fletcher versus Peck, and it would be decided in 1810. In this case, four companies in Georgia would be giving a $5,000 grant to be procured through bribing the legislates, promising shares of land if they support the bill. A new Georgia legislate would be formed in 1796 and would nullify the act, even though many smaller parties such as Robert Fletcher had bought thousands of acres into this land act. This questioned if the government had ability to cancel land act grants, even when it is bought. Eventually, it would be decided that a legislator could not take back any land grant they give, setting a precedent for the use of the contract clause, which prohibits any government from impairing the obligation of contract. McCulloch versus Maryland would be the sixth case in this presentation, and it would be decided in 1819. In 1816, the Second Bank of the United States would be established, with Maryland paying legislating taxes for this bank by 1818. McCulloch did not want to pay for these taxes and called the bank unconstitutional. What a crybaby. The courts questioned if Congress had an authority to establish the Second Bank of the United States and if Maryland was constitutional in the tax levying. It was decided that Congress could establish the bank, and Maryland had no power in levying taxes. This is important today as it shaped how Congress could control economic decisions, such as making the second bank. Number 7 would be Gibbons versus Ogden, and it would be decided in 1824. Ogden tried to forestall a land monopoly over interstate commerce. Gibbons owned a steamboat business and partnered with Ogden for business until Ogden made his own steamboat company on Gibbons' land, which led to him giving Ogden a lawsuit. Excuse me. The court questioned if the Commerce Clause gives Congress the ability to control interstate commerce, in which it was determined that Congress would be able to control interstate commerce through the Commerce Clause. This is important because it sets the precedent of the legislator having all control over interstate commerce instead of the companies. In Era 3, we go to the Taney Courts. Course, court case number 8 is Charles River Bridge versus the Warren Bridge in 1837. In 1785, the Charles River Bridge Company would be selected by Massachusetts to build a bridge and collect tolls, also allowing the Warren Bridge Company to build a free route not far away from the tolled road, which made the CRBC file a suit on them. The court questioned whether the legislator entered an economic contract with the CRBC and if their contract was violated with the construction of another bridge, later deciding that the state had not entered a contract, nor were they obligated to keep free routes reachable. This case is important as it affirms that public and economic welfare is more important than corporate monopolization. Number 9 is Cooley versus the Board of Wardens. In this case would be decided in 1851. Cooley owned a fleet of ships in Pennsylvania. He would be soon fined for not hiring a local pilot for his fleet, which he would sue the state for. The court questioned if the standing pilot laws in Pennsylvania violated the Commerce Clause, and it was found that it did not violate any act in the Constitution. This is an important case because it holds that state legislators can regulate interstate commerce as long as it does not conflict with federal legislation. Number 10 is Dred Scott versus Sanford in 1856. Dred Scott was a Missouri slave that moved to Illinois and Louisiana. In 1857, when he returned into Missouri, he would sue for his freedom. The court questioned whether Scott was a slave or free, and the court mostly decided, holding that if his ancestors were ever imported and sold into slavery, he could not be an American citizen, and could not testify in court or vote in any way, shape, or form. But the case would be dropped as the court has no jurisdiction in this area. Many historians, and possibly including you, Mr. McMahon, would call this one of the worst decisions ever made in the Supreme Court, as it increased tension between the succession. Here's a random NASA fact. In 1985, Space Shuttle Flight 51L was the first mission to bring soda into space. Although both drinks of Coke and Pepsi offered their distinct flavor, they were not chilled, and they were described to be very frothy when dispensed. Many would criticize NASA and both companies for using the opportunity as an marketing ploy rather than an actual science. In Era 4, we have the Fuller Court. In case 11 would be Plessy versus Ferguson. Court case 11 would be Plessy versus Ferguson, and this court case would be decided in 1896. In 1892, Homer Plessy would challenge the Louisiana Separate Car Act, requiring separate but equal accommodations for African Americans on train cars. The Committee of Citizens would test the boundaries of the law by putting Plessy in the white car, in which he was redirected to the black car. He refused and was later trespassed and arrested, in which he appealed. The court questioned if the Car Act violated the 14th Amendment, which is basically equal protection under the law, and it was decided that it did not violate the amendment and the act would remain constitutional. This case is important as it upheld the Separate Car Act, effectively protecting state legislators from repercussions if they separate facilities based on race, as long as the facilities are equal. Court case number 12 would be Lochner versus New York, and it would be decided in 1905. New York had strict baking laws, which stated bakers could only work 60 hours a week, 10 hours a day. Lochner allowed a baker to work longer, which resulted in fines, causing Lochner to appeal it in the second set of fines, arguing that the Bake Shop Act was violating the Due Process Clause, which regulated the seizure of life, liberty, or property. Many in the court also believed the New York laws were unconstitutional, as it failed to be rational even in the slightest. Baking wasn't as dangerous as other jobs such as coal mining. It did not warrant these strict regulations. This would influence much of the progressive labor acts passed in this time period, helping more Americans get safer jobs and get associated with their labor unions. Number 13 would be Adkins versus Children's Hospital, and it would be decided in 1923. In 1918, the District of Columbia's Children's Hospital would be sued by Adkins, who believed the minimum wage law enacted by Congress in order to pay help women workers was unconstitutional, breaking the Due Process Clause, which contained the right of the freedom of contract. The court decided the act to be unconstitutional, relying on similar past findings from Lochner versus New York. This case would provide a stark contrast between freedom of contract and the failure of the government to protect their female laborers from the same work as men, earning almost similar wages. In Era 5, we go into the Warren Courts. Case number 14 is Brown versus the Board of Education, which is the first case in this series. It was decided in 1954. This case was from 5 different states who were fighting federally to keep segregation in schools on the table. The courts questioned if segregating public institutions of education violates the Equal Protection Clause. It was determined that there can be no racially separated facility that is still separate but equal, in accordance with Plessy v. Ferguson, and violated the Equal Protection Clause in the 14th Amendment. This case would make education accessible to millions of Americans who were previously segregated from schooling. Case number 15 is Gideon versus Wainwright in 1963. Clarence Gideon would be charged and arrested for breaking and entering. At court, he requested a lawyer, as he didn't have one. Florida legislated earlier that attorneys are only for the are that attorneys are for good boys, and Gideon would be forced to plead for his own freedom. Once he discovered that he had 5 years in prison on the line, he quickly filed a violation of habeas corpus to the Florida Supreme Courts, as his Sixth Amendment rights were being violated. The court questioned if the Sixth Amendment rights to counsel was further implied to felons, and it would be decided that it was still further implied to all under the 14th Amendment. This case is important as it ensures all citizens, no matter the crime they commit, are entitled to a lawyer from the state free of charge. In case 16, we would see Miranda versus Arizona, which would be decided in 1966. In 1963, Ernesto Miranda would be arrested and convicted for the kidnapping and forced intercourse of Patricia Wire. After being brought for questioning, he was not read his right to have an attorney and was allegedly forced to confess on paper. This confession would be used against him in court, convicting him to a hard life in prison. He would appeal, but he would be rejected by the Arizona courts, as they saw his rights of due process were not violated as he did not request a lawyer early on. The court questioned whether the conditions against self-incrimination in the Fifth Amendment or due process should extend to police interrogation, in which it was found that the Fifth Amendment requires police to inform all suspects of the right to remain silent and right to an attorney. This case is important today as it as it ensures civil protection in an interrogation, and it will ensure no false confessions are given. Lastly, we have Era 6, the Rehnquist and Roberts Courts. Number 17 is Planned Parenting versus Casey in 1992. Pennsylvania would create a series of laws from 1988 to 1989 limiting women on their choice of abortion. This includes a 1-day waiting period before the operation and prior notifying their husband or father before the operation. This case questioned whether or not these provisions set by a Pennsylvania legislator is constitutional, in which it was narrowly decided that it was not. As Roe v. Wade, you should know this one because this is a highly debatable topic even in today's times, absolutely remained relevant at the time of this act's creation. This act is more important as it introduces a system of standards that the courts should follow. These undue burden standards would allow the government to limit abortion, as long as it did not obstruct their ability to receive abortion. Number 18 would be the Citizens United versus FEC lawsuit, which would be decided in 2010. Citizens United would sue the Federal Election Commission in order to prevent the Bipartisan Campaign Act, limited how politicians could advertise their campaign, from stopping their Hillary Clinton movie. This case questioned if the BCRA restrictions were unconstitutional, as many limitations pushed by the act are protected by free speech. They also questioned the validity of the BCRA's restrictions for companies sponsoring political advertisement, as the act wasn't created for or against their opponent or themselves. Lastly, they questioned whether a documentary, such as Hillary, the movie, should be regulated. It would be decided that the prior limitations on political communication would not be considered as protected political speech, but allowed the same communication if there was no intent to call for vote or criticize another competitor, and would make following political documentaries require regulation from the BCRA. This case is influential today as it allowed the creation for super PAC organizations, which are not limited by the BCRA but are still monumental in advertising for politicians, lending almost an infinite amount of money to their politicians. Case number 19 would be the Dobbs versus Jackson's Women's Health Association. This case would be decided in 2022. And a quick thing, if you haven't seen already, I am down there, mainly because if you see there, the title is way too long for me to have the spotlight up there. So, in 2018, legislator in Mississippi passes the Gestational Age Act, banning abortions after 15 weeks as long as the child or mother is not in a life-threatening position. The Jackson's Women Health Organization would challenge this decision in court, being one of the only licensed abortion institutions in Mississippi. This case questioned if the Gestational Age Act was unconstitutional, and the court decided that it was not unconstitutional, and that abortion is not a natural right from any interpretation of the Constitution. This is important today as it still limits the freedom of choice of mothers to abort their fetuses on a federal level unless either or both parties are going to die. To conclude, the United States Supreme Court has been influential in all parts of the United States through their decisions through the past 250 years. Although this slideshow did not hit every single era and every single case of this eras I selected, these cases were still chosen these cases were chosen as they hold the most importance to the ever-changing United States, such as in the case of increasing civil rights for our own citizens, implying certain protections on state legislation, or even restricting the latter. This has been a Robert Godwin Productions.